This video covers the points of consideration for the expert witness's direct examination. It's the third in the series relating to direct examination of expert witnesses. I'll go through these points quickly. Number 1, as you approach the courthouse on the day of your direct testimony, think of everyone you encounter within about 10 blocks of the courthouse to be a member of the jury and act accordingly. Number 2, don't fraternize with the litigation team or enter the courthouse with them. That creates an image that isn't helpful to your status as an independent expert. 3, immediately before you enter the courtroom, put yourself in the right mindset. Relax yourself and think positively about your client, your analysis, and your opinion in the case. Think positively about the American judicial system and the jury system. After all, it is the best system in the world for resolving civil and criminal disputes. Don't allow yourself to think anything negative about jurors. 4, think about your own image as you enter the courtroom. The jurors, lawyers, and parties have been there for days, establishing informal connections with each other, and you're the new kid on the block. Enter the courtroom humbly, but confidently. Think of yourself as the junior person within this group, and you have to earn your place of respect. Number 5, be mindful that expert witnesses are not particularly favored by judges and court staff. You face a slight uphill battle. Be deferential in your initial attitude. I've talked about designing a script of your testimony with your lawyer in the previous video, so I'll only cover the generalizations here. Number 6, when you take the witness stand and you're asked to state and spell your name, look respectfully at the court reporter and give him or her that information. You want the court staff around you to respect you and think positively about you. Number 7, your foundational testimony must be designed to humbly present your qualifications on the issue you're addressing. The foundation must gradually prove you to be an expert and a teacher, but one who is likable and approachable. One who the listener would like to have a cup of coffee with, not a conceited know-it-all. Number 8, at the very beginning of your testimony, before you present your credentials, establish the purpose for your being on the witness stand. In the minds of the listener, a scripted question like, "Dr. Smith, what are you here to testify about today?" will establish the context of your presence there. Number 9, the expert is a teacher, and nothing is more important than speaking to the minds of the listeners. 10, the technical presentation must be organized in a way the listener can understand the logic of the analysis without getting mired in minute details. Next, the organization of the expert testimony should include clear breaks between different areas of the underlying analysis, so the jury can mentally conclude one area before moving on to the next. 12, when dealing with a complicated analysis, it's helpful to frequently break it down to the following 3 steps, or there are 4 factors to consider when analyzing problem X. If you do that, the lawyer can then ask the witness for an explanation of step 1, then step 2, etc. You should design this outline and questions into your proposed script and practice with your lawyer. 13, develop a question and answer series that allows for a balance of short answers juxtaposed with longer answers. Make your testimony interesting and able to be followed by the jury. 14, complicated concepts must be presented with straightforward, simple examples to make them real. Work with your lawyer in the preparation phase to develop workable examples. 15, most people are visual learners, so graphics are very helpful to explain concepts and summarize opinions. Now, the key to graphics is simplicity. They shouldn't be complicated spreadsheets or complex scientific formulas. Regular people can't easily follow these types of visuals. Look at these graphs. Yes, they are colorful and maybe even artistically pretty. But do they easily tell you anything? Can you make sense of them without a detailed explanation? I certainly can't. By contrast, look at these 2 graphs. They may not be as artistic, but they are easy to understand. They clearly show something to anyone who quickly looks at them. How about these graphics that show some scientific formulas? Do they mean anything to you? I would rather see something like this as opposed to a fancy formula. The message is, keep your graphics simple and to the point. 16. Whom should the witness talk to when giving expert testimony? Normally, a teacher will speak to the students, the listeners to whom the information is being conveyed. So without being patronizing, the expert should do the same thing and try to do it in a conversational tone. Look at the lawyer when she's asking you a question, then turn to the jury when answering the question. 17. Don't hesitate to invite your lawyer to interrupt you and request further clarity if your answers to her questions are confusing. For instance, in a complicated part of your testimony, the expert might even look at the lawyer and say, "Did that make sense, Ms. Jones?" Or, be sure you have agreed that you're comfortable being interrupted with a question like, "Wait a minute, Dr. Smith, please go back over the point you just mentioned. Maybe it's just me, but I didn't quite get that." 18. Direct examination should be a structured conversation between the lawyer and the expert designed to lead to a logical conclusion. As the testimony is presented, the lawyer should ask for the expert's conclusion for each step of the analysis. 19. At the very end of the testimony, the lawyer should ask for the expert's final conclusion and whether the expert has reached it with reasonable certainty. Number 20. Be mindful about structuring the testimony so the fact finder sometimes has the opportunity to draw some of their own conclusions from obvious facts. On direct examination, the lawyer should be the conductor of the orchestra, not the soloist. The expert is the soloist. Think of yourself that way. Carefully prepare with your examining lawyer, prepare a script of your testimony, and your expert testimony will be flowing and logical.
Brian Peter Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon. Professor Brinig is available for continuing education presentations and speaking engagements to professional groups.